My name's Tom Cox. I'm a partner in the dispute resolution group at Gowling, and I'm delighted, in conjunction with Quadrant Chambers, to welcome you to this event, which we're putting on as part of London International Disputes Week. I know a number of you are here for the week, and I hope you're having a great time and being warmly welcomed into our city. This session, as you'll be aware, is on global supply chain disputes, how they might be resolved, how they might be avoided altogether. We're going to be digging into some of those topics, and I'm delighted to have a fantastic panel alongside me, actually a truly global panel, as will become apparent in a moment, for a global topic, but I'm delighted to have them with me. So turning to the panel, I'm going to ask you to introduce yourselves, but as part of that, that's partly to check the microphones are working, partly to check the voices are working, but I'm also going to ask you, if I may, as a sort of icebreaker question, and I'm afraid it's a legal icebreaker, so it's not most exciting, but in the context of this talk, I'm going to ask each of you to get out your crystal balls and predict. We're obviously in a time of global shocks that are causing issues for supply chains internationally. For you to predict what you think the next global shock is going to be in 2026 that is going to keep us all in business. So Joe, I'll start with you if I may.
Sure. I'm Joe Sullivan. I'm a barrister in practice at Quadrant Chambers. I practice across commercial law, in litigation and arbitration. 2026, I am going to go for cyber attacks. I think we've seen this year the effect of cyber attacks on supermarkets, for example, the end of a supply chain. But one can see they're increasing each year. QBE says it's about 50% higher this year than last year, and that trend is likely to continue. And it doesn't take much imagination to see the effect of a major cyber attack on supply chains, particularly for just-in-time supply. So that's what I'm going to go for, Tom.
Sounds a pretty good bet to me. Sophia.
Hi, I'm Sophia Alouache. I'm a principal associate at the Paris office, as you might hear from my accent. So for me, the one key disruption that I foresee for 2026 is the implementation of the European directive on corporate sustainability due diligence. Perhaps you're wondering why I speak about that in a post-era Brexit. Well, the answer is quite straightforward. The directive will apply to both EU and non-EU companies. And such companies will be required to take responsibility for adverse impact of their activities on human rights and environment, but not only of their own activities, of the one of their subsidiaries and of their suppliers. So the goal of the directive is quite clear. It is to encourage a company to have responsible business practice. It is a great step forward in terms of accountability and transparency. However, it will raise two main new disputes, I might say. The first one is that companies will have to end relationship with suppliers if they do not apply the duty of care. So this will increase the number of disputes based on unlawful termination. And the second type of dispute is that even if they didn't cause harm themselves, mother company will have to answer about violations of human rights and damage to the environment. So for me, 2026 will be we'll see new legal exposure.
That's super interesting, and we lasted 2 minutes before we mentioned Brexit, so we've done really well. Niels.
Hi, my name is Niels Kupka. I'm a disputes partner at Gowling WLG in Frankfurt, Germany. Practice in arbitration and litigation. I've seen quite a few supply chain disputes in my practice. 26, at least a major risk factor that I predict is geopolitical competition and tension, and how that can affect global energy supply. Seeing, for example, that we in Europe are heavily dependent on liquefied natural gas from the US, China, and Qatar as the big major players. I think the competition between the US and China could have a negative impact on energy supply for us here in Europe, and any other regional tensions that in Southeast Asia that can add to this would just add to the negative impact. Yeah, that's my at least prediction for a major risk factor for 26.
And energy issues from Niels. Tom, we touched on some of the impact of your neighbours. Perhaps if you introduce yourself, and I suspect your prediction may be aligned with your neighbours' actions.
Very close to home. Hello, good morning, everyone. My name's Tom Yates, and despite the English accent, I'm a disputes partner in the Ottawa office of Gowling's in Canada. With the caveat that if I had a crystal ball, I would be a commodities or derivatives trader rather than a lawyer. I think we're going to see continued, trade problems caused by Trump's tariffs. That's not particularly insightful, but I think if I had to guess what would happen is I see perhaps that China using its almost monopoly on rare earth minerals and using that as a leverage in its kind of negotiations with Trump. And if I was in the industry reliant on rare earth minerals, I'd be very nervous right about now.
Excellent. Thank you, Tom. And finally, pass it to Richard.
Good morning. My name's Richard Bilby-Wright. I'm the head of legal at Aston Martin. I left private practice about 20 years ago now, if you feel old. And I've worked pretty much in manufacturing industry since then, majority in automotive. So, automotive is one of those industries that has one of the most complex supply chains out of everything. And it's very global. So it's something that we've spent quite a lot of time on as in-house lawyers. I think 2025 was summed up in my world as instability. I think 2026, we've heard that we're going to have instability again. And I think that's a real problem for business. We have regulations coming out of the US, which are purely political, but impose a huge amount of pressure and resource and cost-intensive activities on supply chains. So we'll have transparency requirements. As an automotive company, I have 1,000 suppliers for a car. I'm supposed to understand tier N level suppliers for every single component to check whether there's any Ouija force labour, or whether under the EU, I have to check whether there's been deforestation, including having satellite imagery of deforestation happening as we speak in a Brazilian rainforest. And then the next time the EU wake up and go, well, that's not really achievable. So even though you spent lots of time and effort doing that, we're now going to delay implementation by 2 years. The instability is what is difficult. And that is very difficult for all levels of the supply chain. So for me, I think it's unfortunately a continuation prediction of what we've seen in 25.
Thank you, Richard. That's super insightful. So that's the future. Crystal balls away. Fortunately, this is being recorded, so whether any of this is accurate or not, we'll be able to judge this time next year, so watch this space. But we're going to put our crystal balls away for a moment. And we're going to move on shortly to the key questions of, what remedies and relief can you obtain when supply chain disputes arise? But I think to ground that, I'm actually just going to ask the panelists, again, very briefly, to share some of their insights and their experiences of what they're actually seeing now in terms of their live disputes. So for that, I'm going to come straight back to you, Richard, if that's okay. Not least because for us, we obviously only see in practice disputes when they've gone beyond the nascent stage and have got to the actually need legal remedy, external lawyer stage. But Richard, you see it all. So from your perspective, could you perhaps just give an overview of the types of dispute that you're seeing and also what it is that is driving that?
Sure. For us, it's always the same sort of dispute with the suppliers, which is pounds, shillings and pence, cents and dollars. So, 10, 15 years ago, costs were pretty stable. Input costs for suppliers were pretty predictable. Nobody was losing a lot of money. The pricing was fine. Now, of course, after COVID and Ukrainian war, we see huge cost inflation. And in my world, I'm building a car which is going to have a 7 or 8 year lifespan. I'll source a supplier 2 years before I even start building it. And at that point, I'll lock in a price. That price is effectively then on a long-term contract which says 10 years. Now, in most manufacturing industries, you'll see some clauses which allow movements for raw materials based on a published index, right? But nobody's writing contracts that say, dear Mr. Supplier, you can change the price anytime you feel like it because your costs change. And of course, costs have gone up hugely in that time period. So you have a lot of suppliers who come and say, I can't afford to do this anymore. I want to change the price of the things, the goods and services that I supply you. Now, on the customer side, the customer says, hang on, I set the price of my product based on the cost that I had at the time on the basis of a budget. It's not for me to suddenly take a whole load of cost on myself just because your input costs have changed. And that's where you see the disputes arising. You get skirmishes where, the supplier says, I want more money, and the procurement team of the customer will say, you can't have it because they've got a material cost target they need to meet. You can't have it. And then things start to escalate. And that's where I think I see most of the disputes. 90% of the time, you commercially come to a situation where you resolve it yourselves. Going to formal dispute resolution is always usually a last step, or it's a strategic step. But I think very difficult or cost based, and at the moment that's where I foresee most of the issues.
Brilliant. Sort of sticking to a degree with automotive, I'm going to come to you next, Niels. Your practice is by no stretch exclusively automotive, but you do lots in the automotive sector. From a German perspective, is that similar to the types of dispute that you've been saying?
Absolutely, and I can fully agree with Richard. This is exactly the type of disputes that I've seen also a lot in my practice. Disputes about price adjustments where either tier 2 or tier 1 suppliers were requesting an adjustment of the prices under long-term supply agreements. And first thing that we look at is whether there is a price adjustment clause in there, price index clause. Very often we see that there are sort of negotiation clauses in there, and then depending on how they are drafted, whether they even give a supplier a right that the parties sit down at a table and start negotiating. And if the OEM, for example, said, no, I don't want to sit down, then tier suppliers sometimes ask for an injunction just because they withheld supply, because they say, look, as long as you're not fulfilling your obligation to sit down with me and negotiate, I'm now stopping supply. So that is what we see during still with the Ukrainian crisis. We of course see disputes about force majeure and material adverse change clauses, discussions at least about that. In Germany, we have a specific provision covering cases of force majeure. It's when there is a fundamental change in what the parties thought is the basis of their contract, their agreement, and if unforeseeable events then happen. So there's a specific provision under a German statutory law that is then always looked at. The hurdles and requirements are quite high. And other types of disputes that we see in the automotive industry are delays where part of the agreement is first an engineering part and then a serious supply part. And then engineering takes longer than expected. And then the question always arises, is the timetable in the contract, is that a strict one? Was that mandatory? Or is the language soft enough that you can say, or read in it, it's just the best effort to achieve the timelines? OEMs would, of course, always say, it's mandatory because I already advertised this new model and I can't wait another 2 years. But price adjustment and delays, I think that are the most typical disputes that I see.
Very good. Sophia.
Yes. Actually, we see the same tendencies in France. Actually, we've witnessed recently an increase in disputes based on inflation. I have a recent example where a chocolate manufacturer came to us because one of his distributors refused to pass on a huge cocoa price hike. And actually, our client said that the contract performance had become too burdensome, excessively burdensome for him. And after careful consideration, our client decided that terminating the contract was actually the only way to avoid worsening his financial situation. And this is actually possible in France because we have a provision similar to that Germany. In France, one article provides that a party can request the other one to renegotiate the contract if unforeseen circumstances make performance excessively difficult. If the renegotiation fails, the party can either terminate the contract or ask a judge to adjust it. And this is particularly useful when you have an imbalance in the bargaining powers, such as in the food sector.
Really ticking all the boxes, Sphere, in terms of we've had Brexit and we've now had French disputes over food. Tom, we'll come to you next.
So I think we're seeing two things in the kind of supply chain area. One is we're seeing disputes where there are just general delays in the supply chain that are causing issues for our clients to meet their own contractual obligations. For example, I've got a current ICC arbitration in the space industry where my client is responsible for designing, manufacturing and launching satellites into space. And it's a very complicated industry with very specialist third parties providing components. And there's been real issues with that industry in terms of accessing components. There's been bankruptcies in launch providers, the people that send the rockets up into space. Virgin Orbit went into bankruptcy a couple of years ago. And that has impacted my client's ability to meet its project timelines for launching satellites for third parties. Fortunately, in my case, the client had the foresight in their project timeline to put, rather than an absolute obligation, to put a reasonable commercial endeavors obligation into their contract. And so they can point to that to explain why there's been delays. It's because their suppliers have been not able to provide components in a timely manner when compared to when the contract was entered into. But even then, we've still got an ICC arbitration that's going to a hearing next year as to whether our client has fulfilled the reasonable commercial endeavors obligation to procure those components in order to launch those satellites into space. The other issue we're seeing, which may not surprise anyone, is tariffs and the impact of tariffs on our clients. We're not seeing disputes at the moment, but we're seeing a lot of inquiries from our clients relating to the impact of tariffs. Obviously, it has a big impact for fixed price contracts. And so we're seeing the type of inquiries of advice of whether the contract is actually a true fixed price contract or whether there's room for adjustment based on whether there's a carve out for taxes, duties, etc., or whether we can rely on a material adverse change clause or a change in law clause.
That's really interesting. It feels like the consensus globally is it's pretty uniform in terms of what these disputes are. And the question then that follows, of course, is from a practitioner's perspective, what can you do about it? What are the remedies, reliefs that are available? So I'm going to turn to you, Joe, on that, if I may. And I think it'd be really interested, for the benefit of the audience here and online, if you could perhaps from a UK English law perspective, give us a feel for the reliefs and remedies that are available on a interim and final stage in the context of supply chain disputes. But in particular, I think we need to look at whether those reliefs are equally available depending on the mechanism through which parties have decided to resolve their contracts, if they're going down the court litigation route or going down an arbitration route. If you could give us a feel for that, I think that would be really helpful.
Sure. Well, if we deal with litigation first, as on a final basis, obviously the principal thing that you'll often be looking at is damages, so damages award from the court following a trial. But there's a lot of other remedies that the courts can give here in England, so specific performance, injunctive relief, declarations as to the parties' rights and indeed obligations under supply contracts. There's also relief that can be given at an interim stage, which can assist in these disputes. So it's possible to obtain pre-action disclosure if that's necessary in order to be able to bring a claim. One can obtain third-party disclosure in advance of a claim, what's called Norwich Pharmacal jurisdiction. And one can obtain other interim relief, which is generally intended to preserve the situation so that the litigation can proceed fairly. So injunctive relief to preserve the status quo, either freezing orders in order to ensure that any judgment that's obtained is enforceable, even search orders in extreme cases if there's a need to preserve evidence when one can't rely on the counterparty to the litigation preserving that evidence for itself. So there's a pretty broad range of relief available from the court. When one comes to arbitration, again, at a final level, very broad relief available in London-seated arbitrations. More or less anything that a court could do, an arbitrator can do, although the effectiveness of that relief is not always going to be the same as if it's granted by the court, because of course relief granted by an arbitrator won't be binding on third parties. And that's a particular issue when one comes to cases involving property and interim relief. One of the great advantages of being able to obtain interim relief from the court, interim injunctive relief, is that it's subject ordinarily to a penal notice, and so breach can be a contempt of court. And anyone who helps the respondent to breach the order can also themselves be in contempt of court. So, for example, if one gets a freezing order, one serves it on the banks, and then the banks will freeze the money. That's not so straightforward in an arbitration. You can go to court to obtain interim relief under Section 44 of the Arbitration Act in support of arbitration. But the circumstances in which that can be done are not always completely clear. Where there's a decision of Mr. Justice Legat, as he was, now up in the Supreme Court, called General Metals, where he said, if you could have gone to the arbitrators to get this relief, then the court won't grant it. Now, given that most institutional rules now have provision for emergency arbitrators, they say they can get those on board very quickly, and indeed the new Arbitration Act makes clear that emergency arbitrators can grant relief in English-seated arbitrations. There are risks in going to court because the judge might say, why are you here? Why haven't you gone to the arbitrator? But in my experience, as long as you can show that there's a good reason, and that could be you need to go ex parte without notice, or you need the order to bite on third parties, usually you'll be able to get what you need.
Yeah, excellent. I think that's really clear. That's obviously the position from an English law UK perspective. And just turning to the panel very briefly, does that resonate, Niels? Is that similar to the situation in Germany?
It's very similar. The reliefs that can be granted from German courts are also quite broad. We don't have the type of disclosure procedures that you have here in the UK. The reliefs most often sought in the types of disputes that I mentioned before is injunctive relief. Actually, there are tough negotiations. It almost never really then goes to proper arbitration or proper court proceedings, but it's more threatening with supply stops, handing in an injunction, or we have a system called hand in a protective brief beforehand, so that an injunction cannot be handed down ex parte. So that is something that we see very, very often in arbitration, because injunctive relief from the courts is always available in Germany, even if the parties have agreed on an arbitration clause. I have to say I see very little interim measures handed down by arbitrators or arbitral tribunals. And I also have to say that if parties agree on the rules of the DIS, the German arbitration institution, the DIS rules do not contain provisions on a so-called emergency arbitrator. The rules were revised in 2018 and expressly avoided such provisions on that. And I think it's makers of the rules, I think it was a sign of trust in the German courts, because they handle with interim measures in a quite timely manner. And so that, I think that was the reason, yeah.
And just very briefly, Sophia, Tom, similar framework, similar landscape in France and in Canada?
Yes. Yes, in France, absolutely. A broad range of interim relief. The main point I'd like to highlight is that when you appoint an emergency arbitrator, the decision he renders when he is sitting in France is an order. It's not an award. So there's not an automatic enforcement, and you still need to go to a court. So actually, it's not that useful to go in front of an emergency arbitrator in France.
Yeah, the situation in Canada is almost identical to the UK. Arbitrators have the ability to grant interim relief, and the courts can and will grant interim relief in support of arbitration if there's particular reasons to go to court, such as my colleague mentioned. The issue of whether there's an emergency arbitrator provision or not hasn't been an issue before the Canadian courts. They don't really concern themselves with that. And like the UK courts, you can get an order in support of arbitration in the afternoon if it's that urgent, but more traditionally you can do it within a couple of weeks. I was involved in obtaining an injunction within a couple of weeks in support of arbitration. And Canada is based, the arbitration legislation in Canada is based on the UNSTRA model law, the 2006 UNSTRA model law, and that allows the enforcement of interim measures by the tribunal. So you can enforce those interim measures ordered by the tribunal, subject to the limitations that have already been mentioned about third parties and the power of compulsion.
So that's, I think, the domestic landscapes, but of course, in the context of this talk, International Disputes Week, but also the nature of supply chains, full stop, which are typically international, particularly for manufacturers in this jurisdiction, for example. The ability to obtain an order or an award is one facet, but then actually if you're dealing with an international counterparty, the ability to enforce it is just as, if not potentially more important, one would think. So coming back to you on this, Joe, and we'll focus from a UK perspective to begin with. Having obtained your order or award, how easy is it comparatively to enforce those internationally? I'm not expecting a blow-by-blow recount of every jurisdiction in the world, but sort of in general terms, can you give us a feel for the routes and the regimes and the comparison between court orders and litigation, arbitration awards?
Sure. Well, I mean, insofar as arbitration awards are concerned, obviously they're very broadly enforceable under the New York Convention. I mean, in terms of enforcing a foreign-seated arbitration award in the UK, it's very simple. You just apply to the court for recognition of the award, apply for enforcement under the Arbitration Act, and there's some procedural requirements. You need like an authenticated copy of the award, the arbitration agreement. But then as long as you have that, there are very limited circumstances in which the court will refuse recognition or enforcement. Things like public policy, if it's contrary to public policy, if it's outside the scope of the agreement, if the agreement itself is invalid, but really quite limited. When one comes to judgments, it's not always so easy to enforce those internationally, as one knows, and depends where you're going. But in terms of enforcing foreign judgments here in England and Wales, under the common law, it's pretty restrictive. So you have to show that the defendant, jurisdiction was established against the defendant either because they submitted to the foreign jurisdiction or because they were physically present when the proceedings were started. You can only enforce money judgments, and the circumstances in which the court will refuse to, or may refuse to enforce the judgment are broader than would be the case under arbitration awards. But we have recently entered into the 2019 Hague Convention. It comes into force on the 1st of July here, and that provides a broader scope for enforcement of awards to the signatories to that convention, which is basically the EU, except for Denmark, the UK, Uruguay and Ukraine. And in those cases, it isn't necessary to show personal jurisdiction. It's sufficient to have the sorts of jurisdictional bases that one would be able to obtain permission to serve out here. So is it a contract that was going to be performed in that jurisdiction? Is it an agreement that was reached in the jurisdiction? Things like that. And a broader range of judgments can be enforced under the Hague Convention. The limitations are much narrower. So exemplary and punitive damages, that can be difficult to enforce. But apart from that, insolvency doesn't fall within the scope of the convention. But otherwise, it's pretty general. Unless it's a judgment that's contrary to public policy, then usually it will be easy enough to enforce.
So I think, from that, I think that's really helpful. Just a quick point on that, though, in terms of interim awards. So if we were to obtain an injunction here and wanting to enforce it in the EU, let's say, that's pretty challenging, is it not?
That's extremely challenging in terms of interim injunctive relief. Partial final awards in arbitrations are easily enforceable, and so if you can persuade your arbitrator to grant you interim relief in the form of the partial final award, which I've done, that then makes enforcing that award, even on an interim basis, much easier. Just so there are challenges there, but there are also ways through. Just to make us, having mentioned Brexit, just to make us feel better or worse about matters. Niels, can you just give us a quick flavour from a European perspective? If you're trying to enforce between member states, how does that compare?
For arbitral awards, even if they are interim or partial, final, the same, obviously. And when it comes to interim measures from the courts, that is governed by the Brussels recast regulation in articles, I think, 35 and 36. And it's actually recognition, at least, quite easy. But I would always make sure that the court handing down the injunction is a court that also has jurisdiction in the main proceedings. And I would always recommend to have not to have an ex parte decision, because that also makes it then easier, even under the Brussels recast regulation, to recognise it and enforce it in the other member state.
And that's really interesting. The mention of Brexit and Brussels recast, maybe for obvious reasons, because that was something that we used to benefit from and no longer do. But Richard, I think we have an example, do we not, of where a scenario where you have got the ability to or do obtain an interim injunction, but it may be that it feels like through the courts, but it feels like there are then barriers to enforcing that internationally. Actually, in a practical sense, in the case we had, that didn't really ultimately matter, did it?
No, I think my far more learned colleagues will be able to talk, and as they have done, about the actual ability to enforce. But there are a lot of intangible reasons why you may still want to take some sort of action, even if enforcement is quite difficult. So in our case, I think it was going to take us 6 months to enforce an interim judgment in Italy, I believe it was. And as Niels has said, if you want to annoy a big manufacturer, the first thing you do is say, I'm going to stop shipping you bits, and I'm going to put your production lines on stop, and the thousands of people that you employ in that factory, you're going to pay them to do nothing. And all those products that you are selling, you're not going to be able to make or sell. And I know you don't hold huge stocks of everything, because who wants to hold a huge ton of inventory on your balance sheet? Right? So if you want to wind up and you want some attention as a supplier, go and threaten to stop ship. What will happen is most likely the manufacturer will say, I'm going to go and get an interim injunction to stop you doing that, because this is my day-to-day bread and butter of running my business. Now, that all comes from a skirmish, probably, as we discussed before, probably about the supplier saying, I wanted something and I think it's damned unreasonable that you've not given it to me. And we've not been able to resolve it. So I'm going to press the red button which says, I'm going to stop your production line. And that will get me some attention. But the attention it will get if you do that is an application for an interim injunction. Now, whether or not that's enforceable for 6 months in Italy, Joe's already said, number one, if you get it, and usually when I look at the times we go, we usually will, because it's just the supplier deliberately breaching the supply contract, the obligation to supply the bits on the dates that are agreed, at the price that is agreed. You're fairly much on firm ground. So number one, you'll get some of your costs back. So, it's not going to cost you £35,000. It will cost you £35,000 less the amount you get back. Number two, from a negotiating position, it sounds a bit like a child in a playground, but it's a little bit, I won, you lost, I won, you lost, which puts a different footing onto resolving the commercial dispute that underlies it. Again, we've seen that sometimes this is useful to actually go to court, because you'll find there's a subsidiary of a larger group who are being difficult and stopping ship or threatening to stop ship. And when they suddenly have to appear in court, there's a parent company based somewhere else who wasn't aware of this going on, and they coming in and go, why on earth are you doing this? You are going to lose this, and we are going to have a judgment against us as a group. So you need to sort it out. And in fact, we had one, I think, where they agreed a consent order on exactly the terms we were seeking from the judge on the morning of the hearing, rather than be embarrassed in front of the judge because their parent company had arrived with their legal team and said, what on earth are you doing here? So, it also sets a precedent that as a manufacturer, I'm willing to enforce my rights. I am not always just going to sit there and watch you do this and not actually take any action, which again, on a strategic bargaining position, gives you a little bit more when you come to actually negotiate this, because we never get to the final injunction, right? The interim is enough to unlock what's needed to resolve the dispute. If it isn't, then we will go and protect our production lines, because that's everybody's bread and butter that works in the factory.
Yeah, and that's also very.
And if you can say something, and if it's well written, it really helps you in the negotiations. Right?
Yes, absolutely.
100%. And the other point I was going to add on that as well is, as Joe mentioned, if you're getting an interim injunction in this country, it's supported by a penal notice, and because of that penal notice, the directors of the company, so let's say it is a company that's based exclusively outside of the jurisdiction, it may be that they take the view, actually, this hasn't been enforced on us domestically, and therefore it's not sort of front of mind. But the reality is, if you have the benefit of that injunction in the UK, that means that those individuals, those directors of that company, they cannot do any further business in person in the UK going forward, for example. So they, hypothetically, the next time they land at Heathrow, if they breached a penal notice by refusing to comply with the order, there could be a policeman waiting for them. There won't be, but there could be a policeman waiting for them because they have committed contempt of court. And that's a further lever that I think is worth bearing in mind.
There'll be one waiting if we find out they're coming.
I'm conscious that time is moving on, so I'm going to quickly move on to perhaps something a little bit more constructive, which is, looking at, for those of you who are drafting dispute resolution clauses, there have been a number of points that have been raised by the panel so far. What are those points that actually you think you ought to be bearing in mind, perhaps by reference to your national position or the idiosyncrasies of your court system or the arbitral tribunals do you typically go to, but what factors might you be thinking about for your dispute resolution clause? I'll start with you, Tom, if I may.
Yeah, I think if you're thinking of drafting a dispute resolution clause in Canada, I think there's two perhaps unique features to bear in mind in addition to other issues such as enforceability and confidentiality. Canada specific, there's two things. I think one is, unlike here in England, we don't really have a system of specialist commercial court judges that are kind of experts in their field that you want to go to, other than perhaps in Toronto. Toronto has a specialist commercial list, but they're the exception to the rule. And so the quality of judges you get can be variable. There may be people that are doing criminal one day, family the next, and then your $100 million commercial court case the next. The second issue, which is as a kind of recent expat that went to Canada, the biggest thing that shocked me was the time it takes in Canada to get to a trial and a judgment. In Canada, the average time is 5 years. Now, that's pretty shocking, and they're changing the rules to try and aim for a target of 2 years, but it's currently 5 years. Now, that can work for you or against you, depending on which side of the dispute you are and what your strategy is. But when you're actually drafting the dispute resolution clause, that's the thing to bear in mind. If you want something rather quicker, go for arbitration.
So overall timing rather than consideration. Niels, from a German perspective, any a key factor that you'd name?
I think, you have to look at your supply chain. Is that an international one? You would probably then prefer arbitration over courts. If it's purely domestic supply chain, which is never the case, but you probably then go for the courts in Germany, because in a supply chain dispute, you actually always want to make sure, if it really comes to a proper dispute, that other parties in the supply chain are also bound to what a court or an arbitral tribunal has found is the right case in your dispute. And in front of German courts, you can, if you are involved in a dispute, you can issue a so-called third-party notice to a third party who will then join the proceedings and will be bound to the findings in your dispute. That is not the general position, the general case in arbitration. There are some rules now. For example, the DIS rules from the German arbitration institution, they have now issued new rules that you can select and then also issue a third-party notice, but that requires that all the parties, all the suppliers along the supply chain then have the same arbitration clause basically in their contract. That is very difficult, but I would discuss that with the client, whether that is feasible or not.
So the ability to bind third parties, and that was something, Joe, that you, I think, referred to at the outset of one of the challenges. Just sticking with you, what was anything you'd point to in particular?
Yeah, I mean, that point that Niels makes is important. You can do that here in the UK as well. In court, you can, as long as you can establish jurisdiction against all of the relevant parties, you can have it all tried at the same time with the same findings of fact that will bind everyone, which can cause problems in supply chain disputes. I've been in a number of them where if you're somewhere in the middle of the chain, you're going to be involved in at least two different disputes. If you have two different arbitration clauses, you can then end up with the risk of findings which conflict across the two arbitrations when you're as a buyer and as a seller. But other considerations are, of course, confidentiality in arbitrations, the ease at which you can obtain interim relief that's binding on third parties, which, as I said before, is easier to do in the courts than it is in the tribunal. And then in cases involving property rights, obviously tribunals can give awards, give declarations of trust, declarations regarding proprietary interests. But again, those have no in rem effect. And so insofar as third party recipients of that property are concerned, you're going to need to pursue new other proceedings in order to give effect to the findings that you've had from the tribunal.
So if you need to go and get your stuff, that sort of claim.
Yeah, you won't be able to enforce the award against the third party.
Finally, turning to you, Sophia.
Yes. So for me, two factors should be pointed out. The first, we mentioned it, it's confidentiality. It's actually key when you are, depending on the industry. For instance, in pharmaceutical, in energy, it can be crucial to have only a few people that are involved in the dispute. And the second factor for me is less of a factor than a question that I think you should ask yourself when drafting the clause, and it is whether you should or not add a compulsory mediation or negotiation phase for 3 months, for example, before moving to arbitration or to court. ADR, alternative dispute resolution, is actually highly effective because parties can shape their decision. They do not have to wait for an arbitrator or a judge to decide for them. It is also a way to restore the dialogue because people are forced to gather around the table and to start to speak again. And the last advantage of adding this clause is that an escalation clause with an ADR helps you speed up the resolution process and reduce costs. So it's a huge impact.
And that aligns, Richard, with what you said, I think, at the outset about how the majority of these things get resolved commercially. I intentionally asked the private practice lawyers and barristers first, knowing that, having said I talked to them, actually you're the one who can actually tell us what you actually do from an Aston Martin perspective. So perhaps you're prepared to share whether you agree with any of this, whether they've been talking complete rubbish.
Of course I agree with everything that my panellists say. Look, I think the key is it's not always a one-size-fits-all, right? And there's a temptation that when you come to some standard terms and conditions or a standard contract, someone plucks a precedent off which says we'll do non-binding mediation and then we'll do arbitration and then we'll have a choice of law which somebody wants to be in England and Wales, the other party wants to have it neutral next door to where they are, which speaks the same language and is very similar to the law that they're used to in their own territory. If that happens, just pick Brazil or somewhere and then see if they want a neutral jurisdiction. But the point is, I think you have to look at what you as your client or me as a business wants to do. So we very much have a compulsory mediation step, right? Terminating a long-term relationship with a supplier is really problematic for them, right? Let's remember they've invested a whole load of time, capital equipment, D&D. Most of that's going to be amortized over a period of supply of parts. So if we terminate in year one, all that investment is not going to be recovered. So they're very reluctant to just walk away from all that unless they really, really have to. They also lose the revenue. The sales director loses his bonus for the year. Right? And from a manufacturer's perspective, if I want to resource a steering wheel which has got an airbag in it, that is going to take me 18 to 24 months and probably cost me about £15 million of engineering cost. I have to crash test cars. And so there's no easy break here for either party, and neither of them wants to have that sort of relationship and that break. So for us, it's very much compulsory mediation. We want to get the right people in the room at the right level to try and resolve this, right? To give everybody a chance to feel that they've actually got an opportunity to resolve this. Strangely, and probably a little bit strategically, we then don't have arbitration. We have straight litigation. Probably the strategic reason for that, in my warped mind, is most of our suppliers supply lots of other car companies, as suppliers supply lots of pharmaceutical companies. When it comes to confidentiality, they're probably the ones who want to keep this confidential more than I do, because that is going to set a precedent and get them a reputation with all their other customers. So strangely, by having litigation, it probably puts a little bit more pressure on people to resolve it earlier in the mediation. And of course, what people forget is you can change your mind. So if as two people we say, actually, we don't want this to be out in the public and we want to be well, let's agree to go to arbitration then. Or, we're having a big dispute about whether a part that someone or a goods that someone provided has met the quality requirements. Well, there's no point asking a bloody judge whether this steering wheel works properly or not, is there? There's no point asking that arbitrator either. What we'll do is we'll have an expert determination and we'll go to an institute of mechanical engineers or something else and we'll have an expert decide to do it. So I think you can be flexible. Clearly, you have to look at who your counterparties are. If you want it to be enforceable, arbitration is going to be easily more appropriate for certain jurisdictions, right? For Chinese counterparties, we will always have a Singaporean arbitration clause. There's no point having an English law jurisdiction clause, right? So you have to be able to flex your standard position appropriately, depending on who the other side is. But I think the key is to understand, as a business and your client's business, how do they actually want to resolve the disputes practically, not just put the precedent and shove it.
I suspect everyone in the room and online will agree that's absolutely great advice. Conscious of running slightly short of time, and I do want to leave a little bit of time for questions in case there are any in the room. So the last topic I want to cover is moving away from the we need legal redress now stage and looking at that topic, what that looks like. I was going to come back to you, Richard, in the first instance, but also ask the rest of the panel. If you could come up with one sort of top tip or similar, what would it be to help parties, and your recommendation for us to recommend to our clients, help parties to avoid the disputes in the first place, or supply chain disputes in the first place, or to help resolve them at an early juncture? So I'm afraid I'm going to make you work for your dinner.
Short time, just some bullet points. Number one, don't ignore it. Right? There's a temptation to just keep batting the issue away. That just creates more and more tension until it boils over. And when it boils over, it becomes a dispute that you have to resolve. Secondly, people want attention, right? They're doing this because they don't feel they're getting what they reasonably deserve to get. So getting the right seniority of each side to talk about it, rather than just letting it bubble at the bottom, will sometimes sort of resolve that. And the other thing is, when you can be fair. I mean, I quite have a lot of people who will have an argument about pricing, and they'll say the supplier wants a load of money. And I'll say, if we had to go somewhere else, would it cost more or less? If the answer is it costs me more, then I need to do something here, right, to maintain that relationship. Give myself a little bit of leeway, give them a small price increase, and perhaps, that's the carrot rather than I'm going to sue you stick. And perhaps team it up with another price review in 12 months' time to see whether we can take that increase out. Or I would like some annual economics, some price reductions based on time. Offer something if it's going to benefit you. Don't just stick your feet in the ground, because the alternative may be worse than the current one you've got.
Brilliant. Tom, you touched on tariffs earlier. Have you got any tariff-related suggestions, recommendations?
Yeah,
perhaps the contracting stage.
Yeah, in terms of tariffs, it's an obvious point, but everyone seems to be looking at it now belatedly. But when you're drafting it, make sure your pricing, especially if it's fixed pricing, is net of taxes, tariffs, duties, imposts, etc., so that you make clear that the risk falls on the customer rather than you as the supplier. And on the supply chain, again, it's an obvious thing, but try and build in redundancy and resilience in your supply chain. That might not be easy if you're buying Aston Martin steering wheels or complex optics in satellites, but where you can build in redundancy, do so.
Niels, any top tips from your side, perhaps based on some of the disputes that you've seen over the years?
Then I go for the delay disputes that I've seen many cases where engineering was part of the agreement, and where then disputes arose around is the timeline binding or not, and I would say or recommend make sure that the wording in this context is accurate, so that there is little way to have discussions about that.
It's real clarity around what the timing requirements are. Sophia, I'll come to you last.
Yes, so for me the advice would be proactive contract management and anticipation. So you can adapt the force majeure clause, you can integrate the possibility to renegotiate the contract, and you can actually anticipate the dispute by selecting the forum and ensuring that throughout the contract chain, the group of contracts, there's a consistency in the dispute resolution forum, as you said earlier.
So continuing to review your contracts, review those force majeure provisions, particularly in light of things that we can see occurring in the world, and making sure that there's clarity over whose responsibilities lie where. I think in terms of from the panel discussion part of the session, I think we're pretty much at an end. But I don't know if anyone in the room has questions. My colleague Sean, I know, has been manning the virtual chat, and there are no questions, I'm pleased to say. If anyone's got any questions here, I think we'll bring a microphone down. Yes, sir.
Thank you. Doan from City Law School and Greymore. My question is to Sophia. You said that under French law, you can get a judge to revise a contract if there has been an excessive change, etc. How common is that? I mean, how have you seen cases in practice where the judge has actually rewritten the contract, or do they shy away from that exercise?
It's actually very rare because the French judge tend not to interfere in the parties' agreements. So, for instance, if you go in what we've seen for now, because it has not been in place for a long time, but what we've seen is that judges tend to ask the party to try a mediation and to try to find an agreement. So even if you go to them and say, okay, we discussed, we didn't find anything, they'll let you exchange one statement of claim, one statement of defense, and then ask you to go back to the discussion. And usually parties find something, at least from what we've seen so far.
So you don't see the judge kind of opening up the draft contract and rewriting it?
No, it's very rare.
I can confirm that also from a German law perspective. It's German law. It's also very rare, but just the fact that such a provision exists, and of course there is a huge grey area because it's not crystal clear how a judge would decide a case. It gives either the one party or the other a lot of bargaining power in negotiations.
Just bringing you in here, Joe, if I may, because that was something that struck me, the existence of that kind of statutory provision. Obviously, in terms of the way that the courts interpret our contracts, the direction of travel for the last decade or so, has it not, has been sort of away from that kind of intervention in any way?
Yeah, I mean, outside of consumer legislation, there's just really no way for the courts in England to do that. They've taken it's effectively a policy decision that favours certainty over sort of, I suppose what some would say, individual cases of fairness, and that's reflected in, for instance, the approach to frustration, which sounds similar to the French and German rules regarding frustrating events in contracts, but in England, people raise it a lot, but it's almost never successful. The parties are pretty much held to their bargain in England.
I've got another question here, Chris, I think.
No, very interesting discussion. Noor from Kadim's. I also work with Field Fisher. We've talked very generally and about interim relief and injunctions, and I understand from Richard that these positions of when you do get them, that's very rare because you've got a very straightforward breach of contract case, but in other instances you might have other issues in play, sanctions that might come into play. We didn't talk about them. I was just wondering to Joe, do you have any examples of case law that where judges have considered these cases and that we could look out for from an English law perspective?
In terms of injunctive relief, there's absolutely tons and tons of case law on it, but there's a UniCredit case recently where the courts looked at the approach to injunctive relief. There was a case actually just this year, the name of which will escape me, Tom may know, Court of Appeal decision on freezing orders, where the threshold test in terms of merits for a freezing order was revisited. Do you remember that?
I can't help you on that, but I can help you on, but I'm sure we can pick up afterwards, that the area I can help you on, and this is a shameless plug, but I'm going to make it nonetheless, it is true that there are comparatively few reported decisions where specific performance of has been granted in terms of, in particular, say an automotive contract saying, you are going to continue supply pending X. Actually, I think Joe or Richard made reference to a decision we had a couple of years ago where actually that order, it ended up being granted by way of undertakings it was Richard on the steps of court, but that was something that was granted. But the reason I mention it is in that hearing, the head of the commercial court referred to the willingness of the commercial court to grant those orders and mentioned two cases. Those two cases, as it turns out, were actually cases that had been done by this firm, which is the reason I'm shamelessly plugging it, because there aren't that many of them. This firm in a different form previously, but there are not a huge number of them. But the courts and the commercial court in particular is prepared to grant those orders. So I can certainly share those cases with you. They are rare, but as Richard said, I think part of the reason they're rare is not because the court is not prepared to grant them. Mr. Justice Foxton was very clear that actually the commercial court is prepared to grant those orders. The reason they are rare, in my view, is that, as Richard noted, often it's pretty straightforward. Someone's banged to the right. They're required to do something and they're not doing it. And if the necessary consequences are then in place, i.e. this is going to cause redundancies, huge issues, losses that can't be compensated by way of damages. If that is the case, and it's so straightforward, then actually a party who's on the wrong end of one of those applications is going to look at it and go, well, actually, we can't fight this. We're going to lose. We're going to be on the end of a penal notice and a major cost award. So therefore, we're not going to fight it. So I think the reason why there are not that many cases reported is not because the court won't grant them. It is because actually in practice, parties back down.
The other thing is that for urgent ex parte injunctions, the judge often gives extempore judgments that just then are not reported, and then it all settles before the return date, so you just never have a record. I remember going to a talk about 5 years ago from Silk, talking about an injunction that he got. He said it's the first injunction of this kind. Everyone in the orders, I've been doing this for sort of 15 years. But it's just never, it was the first reported case of an injunction. Yeah.
Hi, Tedra, it's CMS. Thanks everyone for a really interesting discussion. With some of the complexities of these long, complex international supply chains, geopolitical, CS, triple D, etc., it seems there is some rationale for vertically integrating and consolidating some of those supply chains, and I think we're seeing some of that in the automotive industry. I was wondering if you're seeing new types of disputes arising out of that. I mean, it strikes me that there are complications if customer-client relationships are suddenly becoming competitor relationships. Do you see trends emerging in that regard?
That's not something I'm looking at you, Richard, to the extent that something that's come across your radar. It's not something that I confess I have come across. In automotive, there is a very different approach depending on which manufacturer you are. Niels would probably say to us in Germany, there's the big three German auto, VAG, Mercedes-Benz and BMW, and none of the three shall speak meet, and if you leave one and go to the other, you will never be welcome back in Munich ever again. There's that approach. There's the approach which other OEMs take, which is slightly more collaboratively working with competitors. And for small OEMs, manufacturers such as ourselves, we don't have the resources of the BMW and Mercedes to go inventing brand new technology at great expense. So if there's a proven technology which happens to be owned in a supply chain by a competitor, so be it. Right? We look for brand differentiation elsewhere. Obviously the Chinese manufacturers, domestic manufacturers, have shown how successful it is if you try and keep supply chains within your own group. BYD, Build Your Dreams, famously, virtually owns the mine that the materials come out of, all the way to the dealers that sell the cars. Produces absolutely some stability. You've got to have deep pockets and a lot of management skills to be able to pull that off. But at the moment, I don't see a lot of friction in the industry around that. There's a lot of uncertainty. I think any certainty you get working with another partner is a benefit to share some of the cost. We've seen a lot of EV volume softening, which has left a lot of OEMs and a lot of suppliers in significant amounts of distress. There was only a supplier yesterday that said to us, could you do anything with 20,000 plastic door handles that I made for Fisker? Don't quite fit my DB12. It's a nice question. So I think at the moment, automotive is definitely, and possibly other industries, are definitely just sort of trying to stabilise what they're doing. They're not really falling out with each other very much at the moment, and really don't want to fall out with their suppliers. It's more about how do we manage the macroeconomic issues which are causing us a whole lot of difficulty and churn. Not sure that answers the question.
Thank you.
I think I'm conscious we are now 5 minutes over time, so we probably have time for one more question. Mr. Chorley had a question.
Thank you, Tom, at the outset for having me here. Thank you all the panelists for enlightening us. My question is, although we are talking about 2026 futuristic perspective, international rescue, I am handling two matters back in India. I am NPS Chawla from India, New Delhi, where we are still carrying on that legacy and the dispute arising out of COVID pandemic, force majeure. So my question has two parts. One, what's your experience, and anybody can take this up. One, what's your experience, whether actually you are still facing, because I am dealing with two matters, dispute arising out of non-performance of a contract in COVID pandemic time and the vague language of the force majeure clause, and when one can argue about doctrine of frustration as well. One. Two, how you have now changed, because we have also talked about drafting of the contract and the clauses. Now considering and keeping that in mind and the impact which we have already suffered of pandemics like this, what change you have done in your contract drafting in maybe in your respective jurisdiction? That's my two parts. Thank you.
Well, I mean, as to the first part of the question, yeah, there has been a lot of COVID-related disputes, which typically depend upon force majeure or frustration arguments. And my experience is that in English cases, or English law-governed cases rather, where there's a sufficiently clearly drafted force majeure clause, then it's okay, and the party that wants to rely on it can. Otherwise, the argument never works. Frustration pretty much never works on the basis of COVID. And as to drafting, I have to leave that to someone else, I think.
Yeah, I think the only thing I'd add to that is I would say, from a litigator's perspective, as Joe said, unfortunately, been something of a damp squib. And I think we had lots of, immediate aftermath of COVID, obviously had a huge number of inquiries about what this means for our contracts. But actually, in terms of, from my perspective, translating into big disputes, that hasn't happened. On a drafting side, the particulars of which I wouldn't pretend to talk to that. My colleagues in the commercial team, I know, have amended their provisions accordingly, but I wouldn't be able to give you the details on it. I don't know whether anyone else on the panel has anything particularly to add on that, but it is something that is obviously, as with all things, in the same way as it is, as Sophia rightly said, major events like that do cause, or should cause, parties to think about and revise their force majeure provisions. That's something we absolutely have done and advised our clients to do, but I probably can't give you the specifics on how it's been adjusted, whether it's specific, and there are arguments about what is or is not a pandemic and all those kind of categorization questions. So I'm not going to negligently give you advice on that now, but I'm sure my colleagues can give you proper advice. Any comments from the rest of the panel?
Yeah, I think after COVID, we suddenly saw people facing the realization that force majeure clauses aren't a cure to all ills, and especially as English law, same as Canadian law, they're creatures of contract, and so you either fall within it or you don't. And a lot of people assumed, that COVID would be a force majeure event where we're dissatisfied, and then as a result, they've redrafted their force majeure clause to include pandemics, epidemics, etc. And what I'm seeing now is that same process being carried out, but in relation to supply chain issues, global disruptions, tariffs. So again, we're getting the same queries. They're going, I can't do the contract anymore because my supplier is saying it's now going to take 2 years rather than 1 year to deliver these goods. Surely that's a force majeure event. And we're saying, well, let's have a look at your force majeure clause. No. And now we're seeing on the commercial side, people redrafting their force majeure clauses wider and wider to include those types of things. And again, wherever you can get away with that is a matter of commercial negotiation, power balances, etc. And sometimes we're seeing it of parties agreeing to that type of language as a customer, but making it conditional on, well, if it's not cured within 6 months, I have a right to walk away without liability. So there's normally like a cost to expanding your force majeure clause.
I'm conscious that lots of people have tight deadlines around disputes week. So I think I'm going to pull stumps on it for the English expression here. But to the extent anyone wants to continue those conversations, there is tea and coffee outside. That just leaves me to thank you all so much for attending, both in person and online. I'd like to thank in particular the business development team of Gowling and of Quadrant for the efforts they've put on to host this event. But more than anything else, please can I thank my panellists for what I hope has been a really interesting discussion. From your perspective, it's certainly been very interesting from mine, and I'm grateful to them for their time and hard work. So if we put our hands together and